PhD in Progress seminar series. This is the third phase of the series that's been organised by the Global South Network. And I'd like to start by thanking the organiser of this seminar series, Dr. Nauman Rayat from the University of Leicester Law School. Nauman's a lecturer in law, and he's also the founder and convener of the Global South Network. I'm Di Levine. I'm based in the School of Criminology, Sociology and Social Policy at the University of Leicester. My research has focused on the ways that children and young people survive and thrive when life is challenging, for example, in relation to child abuse, neglect, maltreatment, child protection, and also climate change. And I'm going to be chairing the session today, so I'll be the one cracking the whip on the time. We have a discussant for today. Dr. Ishta Sharma is our discussant. Ishta is the assistant professor in the Faculty of Law at Rajiv Gandhi National University of Law, Punjab. Prior to joining her current location, she worked as an assistant professor at the School of Law at the University of Petroleum and Energy Studies in Dehradun. Her doctoral research is on the emerging dimensions of the writ of habeas corpus from Guru Nanak Dev University in Amritsar. She's also participated and presented papers in national and international conferences and has been invited as a person on several panel discussions at the national level, as well as judged national and international moot court, ADR competitions, etc. Dr. Sharma's areas of specialisation are constitutional law, international law, human rights and gender justice. We also have a fantastic peer commentator for our session today, Samuel Gonzalez Catano. Samuel Gonzalez Catano is a Mexican lawyer and political scientist, currently pursuing a JSD at Yale Law School. I note the jumper, where he also obtained his LLM in 2022. He's collaborated at Isonomia, a prestigious Mexican journal on law and philosophy, and served in several positions at the Mexican Supreme Court and the General Consulate of Mexico in New York. Samuel's research interests include comparative law in Latin America and the Global South, legal and judicial politics, and human rights and democracy. And last but not least, I'd like to introduce our guest speaker for today's session, Mateo Merchan Duque. I hope I pronounced that correctly. I did practice it. Mateo is a JSD student from Colombia, and he holds an LLM in International Legal Studies from New York University Law, where he received the Dean's Graduate Award. Mateo worked for the Special Jurisdiction for Peace, the tribunal created in Colombia after the 2016 peace agreement. And in the tribunal, he participated in designing the special restorative sanctions imposed on perpetrators who fully acknowledged their responsibilities. Moreover, he trained more than 150 attorneys who represented victims within the procedures of the SJP on issues related to the rules of operation of this tribunal. Between 2020 and 22, Mateo was Professor of Constitutional Law, Legal History, Legal Research Methods and Legal Argumentation at the Pontificia Universidad Javeriana. And today, Mateo will present their project titled International Human Rights Tribunals in an Era of Democratic Backsliding. Very timely. Mateo, I'm going to offer you 30 to 35 minutes for the presentation. Then we'll have 5 minutes for comments and questions from the discussant and peer commentator, and 15 minutes for questions and answers by attendees. So are we all set with the slides now? It looks like it.
I thank you. I just have,
Yes.
Yeah, I think that's the previous one, because the one that just sent you has 12 slides. So
Okay.
probably it's just a minor change, but I can start.
Yeah, go ahead.
Okay. Thank you so much. Thank you so much for inviting me to participate in this conversation. To me, it's very helpful. I just started my PhD, my JSD here at NYU Law, first year. So this is not a complete research. This is part of what I'm doing for my candidacy paper, and I hope to hear your comments and suggestions about this. That's why maybe I will sorry, I will do a shorter presentation. That's right, that's the one. Thank you so much. A shorter presentation because I'm interested in hearing your comments. So as was mentioned in the presentation, the original title of the of my project was International Human Rights tribunals in our era of democratic backsliding. But I'm still deciding what's the proper title and the proper focus of the project. I started with a different research question, then I'm moving to different ways. I will explain you a little bit about that. This project and the general interest in this project started with my work on comparative constitutional law, and and the idea to understand the problem of democratic backsliding out of the now probably the most studied cases of Hungary and Poland, and trying to go to Latin America that has received kind of scholarly attention, but also to Africa and to the African Tribunal of African Court of Human and People Rights, which has received less scholarly attention. So I'm trying to combine both fields, work on both fields, comparative constitutional law and international human rights in this regard. And another observation I did when I started this project was that the literature on democratic backsliding, it's so concentrated on domestic remedies, and I would like to offer some input from the international human rights side. This slide shows what I'm calling like the kind of background problem and what it's interesting to research on this. And this is the problem of democratic backsliding that we have in many jurisdictions around the world. Here I have the pictures of the former president Hugo Chavez in Venezuela, the president of El Salvador, in Nayib Bukele, who just changed the constitution to run for re-election and kind of captured the Supreme Court to allow him to run for the office again, and the president of Benin, Talon. And I'm interested in Benin because Benin was considered during the 19th kind of well-functioning liberal democracy that now it's getting in this backsliding trend through a set of constitutional reforms that allow to the president to control the court, to control the electoral commissions, and to reform the constitutions in a more or at least less deliberative way. So, and this is the basic assumption of my project. I will wrap up this at the end of the presentation, but this is very important. I started with a question of legitimacy. Legitimacy for international institutions to intervene in democratic backsliding processes. And my basic assumption is that, no, please come back to the second slide. Thank you. My basic assumption is that there is no democratic authority to abolish democracy at all. Which means basically that regardless of and this is part of the problem of democratic backsliding, and it's not taking the shape of the classic coup d'etat, you know, like we're throwing the government through the military, through armed forces, and this is kind of incremental and systematic process where these leaders use democratic means to undermine democracy. But my basic claim here is that even if you use those democratic means, it's not legitimate to use those means to abolish democracy at all. Please continue to the third slide. I think I can move it here. Yeah. So to present that claim that there is no democratic authority to subvert or abolish democracy at all, I'm concentrating the basic, or you would say the minimal definition conception of democracy, where the system, the institutional conditions grant the capacity of different parties and people to run for the office, where there are competitive elections, then there are promotion and accountability means, and where political rights are granted. That's the basic assumption of democracy that of democracy that I'm working with, especially because I don't want to work out this whole discussion of what is democracy, of uh, of whether we should expect substantive outcomes from democracy, of what is part of democracy, as for example, the discussion of social and economic rights. I'm trying to avoid that. I'm concentrating in this core-based principles, elements of democracy, especially accountability is one of the sorry, I have a cold, so sorry because my voice is a little bit. I was saying accountability. Accountability means has been very relevant in the case law of the Inter-American Court of Human Rights, because the court has ruled on the independence of the judiciary in several cases. 2 weeks or 3 weeks ago, there was a new decision about Honduras. There are decisions about Ecuador, of course, Venezuela, Peru. I will mention a little bit that later. But I think that keeping my focus on these core elements will allow me to see what are the proper scenarios for intervention from an international court should be not just justified, but one would expect a successful outcome from that intervention. Okay, so there is a lot of literature on judicial accountability, on the role of courts as protectors or guarantors of democracy. On the one side, there is this idea of courts as democracy builders. Classic examples, I guess, are, and in comparative constitutional law, the usual suspects are Colombia, India, and South Africa. This is just this is the picture of Álvaro Uribe. He was president in Colombia from 2002 to 2010, and he tried to reform the constitution, to amend the constitution to run for a third term, and the constitutional court in Colombia struck down their amendment using this doctrine of unconstitutional constitutional amendments. That is kind of the basic reasoning of the part of the reasoning of the Indian court, with this idea of the basic structure. And well, and South Africa is another story, because they had the function to oversee the constitution at all, and this famous decision about the certification case where the Constitutional Court in South Africa reviewed the final constitution adopted by the Constituent Assembly. I'm not challenging that idea that domestic courts can play this role as guarantors of constitutional democracy. There is a kind of revisionist process on the outcomes of those courts, especially in India and Colombia, where it seems to be the case that the Supreme Court in India and the Constitutional Court in Colombia have used the constitutional amendments to entrench their own interests. There's a couple of papers on that, and there is a whole discussion about that. But I'm not challenging that. But what I'm saying is that this these are exceptions. This is exceptional. There is not a single constitutional or Supreme Court in Latin America that have that has challenged, as the Colombian did, executive in this in a in a scenario like the Colombian one. I'm thinking, for example, in these cases of Central America, where basically all the constitutional or Supreme Courts in Central America say that running for the office, for the presidential office, was a human right. So and to some extent, those decisions stirred powerful national executives. So this is a kind of exception. That was I thought, well, we always say that courts are the first actors in kind of slowing down or stopping democratic backsliding processes, but at the same time, courts are the first victims of democratic backsliding. So this is what I just said. The judiciary tends to get captured in the long term. As I say, the Colombian case is a kind of exception. So I I thought, well, maybe international courts played a kind of complementary role. I'm not very sympathetic with this idea of international human rights courts as kind of supranational constitutional courts. I think that idea has many problems. I'm exploring that. I will mention that as well later. But I think that two basic ideas may at least prima facie suggest that international courts and international human rights courts could do something in this regard. First, these courts have more capacity to remain immune from capture by the executive because of the appointment process, because of the conformation of like the formation of the court at all, because of the procedures, because of the who can get to the court, and for sure, international human rights courts offer an additional forum for contestation and accountability of states. But that's not the whole story. I will mention the case of Uruguay later, but I think that, and I started with this question of legitimacy, and I wanted to stop there, thinking about the legitimacy of the intervention of courts, but then I found that the approach of international courts may may produce more backlash, more lack of compliance, more criticisms to the international system than a kind of democratic protecting effects that I'm looking for. And the reason of that is that this is the kind of sociological and contextual informed side of my research. The democratic backsliding trend is characterized by this idea of disempowerment and polarization. I think it's not right to present people that vote for authoritarian leaders are just like people with authoritarian characters that don't understand what don't understand the system, that don't understand the benefits of the liberal democratic tradition, the liberal democratic institution, and it's part of my kind of I'm working on this literature that it's saying, well, we have to acknowledge that there are there is a justified claim on these people that that to some point that are upset with the democratic system because they don't get security. They don't get. They see that the economic crisis um, surround them, that they see that the traditional institutions are unresponsive to their claims, to the claimant. So and this is the part I'm working more now, and I'm trying to see how this idea of courts and international courts more as elite institutions that do not have the kind of uh, understanding of the contents where are they ruling, may affect the way that international courts intervene. That's the question about legitimacy. It's not a no. I'm thinking about effectiveness of the intervention, considering the backlash against the court, the way the court kind of it's responsive to the context. This is the case. This is a picture of Uruguay, where where the Inter-American Court ruled in the Hellman case, and basically struck down an amnesty law that was approved after one referendum, after public discussions in the Congress and in the kind of citizen assemblies, and there was a long-lasting political discussion about the amnesty law. And regardless of that, the Inter-American Court voided that amnesty law, despite of of that. We would say that Uruguay is a kind of democratic state. It's the kind of more democratic, one of the most democratic states of Latin America. I'm for sure that decision produced backlash against the court. And the other picture is the president of Rwanda, that where a decision of the African court made the government to basically challenge the status of the court as a legitimate institution, and the government started the process to withdraw the protocol that allow individuals to get to the African Court of Human Rights. So these are my two questions. What are the various conditions contributing to determine whether a particular international human rights court intervention will likely to have democratic protecting effects? How should these courts make decisions responsive to those conditions? And the second part of the question has to do with the normative claim I want to do after my case analysis. This is basically I'm working with the two courts, with the African and the Inter-American court, looking at cases where the courts intervened, and using those cases where decisions were most challenged as kind of contrafactual cases for assessment. I'm trying to, with this comparison, I'm not comparing the two courts. I'm comparing cases within both courts to find out the conditions that may be likely to have to have to get successful effects on that may likely to get democratic protecting effects when a given decision, when a given intervention of the court is taking place. So I'm doing that kind of reconstruction of the cases, and then I will try to propose a way of how those courts should adjust the way they rule to be kind of responsive. For example, and there is a large amount of literature on this, changing the remedies, even acknowledging in the in the decision that the risks of lack of compliance it's high, which will impact the way the court delivers the language used in the decision, um, and uh, and that this is a kind of way to present a non-ideal theory for adjudication, responsive to those conditions. And these are my three main ideas. As I said, there is no democratic authority to subvert or abolish democracy. Judicial review is prima facie one legitimate institutional mechanism to protect liberal democracy. But judicial institutions, particularly international courts, must ponder the context and calibrate the decisions considering the expected outcomes. As I said, this is a work in progress. I'm still thinking of many of the things I mentioned, and I'm sure that your comments will be very helpful. Thank you.
Thank you so much, Matteo. That's absolutely fascinating. Do you want to cover these last couple of slides, or are you happy for us to open up the floor to our discussant and peer commentator?
Yeah, we can open the floor. Thank you so much.
Fantastic. Yeah, I don't know, Samuel or Ishmita, perhaps you would like to go first, Ishmita? I think you're on mute, sorry. When the end of days comes, we're all just going to hear you're on mute in the background.
Yeah. So
Thank
am
you.
I audible now? Yeah.
Yes, you are. Thank you.
Yeah. So good afternoon, Matteo, and good afternoon, everyone here. It was a wonderful presentation. So to ask, like, since in your I went through your abstract, you've mentioned about Ellie's political process model, right? And that political model is a system of constitutional adjudication, and it's a model of a dialogic process of constitutional dialogism. And since you're dealing with international human rights tribunals, first I intended to ask that do you also intend, since it's a working a work in progress, do you also intend to look at the cases of ICJ, like International Court of Justice, and recently in the light of flagrant human rights violations that have been taking place around the globe? We've seen the double standards of international law have emerged in the various kinds of disputes that are coming up before the international human rights tribunals. And since you're proposing this model of constitutional adjudication of can we call it that currently we can say it's like a kind of a diagnosis without a cure? Because the double standards that which we are seeing in the adjudication of disputes and the way the arguments are coming out before these tribunals, so it's a kind of a diagnosis without a cure that you're talking of in your abstract through this model of constitutional dialogism. I hope I've got my question across to you.
Sorry, can you repeat?
Yeah, I hope I've got my question across to you. Was I audible to you?
Yeah. What's audible? Yeah. No, I was going to ask if I should wait for the other questions or should I? Okay. Well, but so let me ask you something just to clarify. So you say that as the way I'm presenting the project, it seems like kind of diagnosis of the problem of the challenges these courts face in the way they adjudicate on these
like
issues.
I wanted to ask, like, you've proposed this Ellie's model, which is a model of constitutional dialogism, where in this adjudicatory process, it's a process of judicial review where they engage in a dialogue. But in the light of the flagrant human rights violations, don't you think this approach can, it has a kind of double standards that are emerging in the approaches being followed by the courts as well in dealing with the kind of dispute that comes up before them?
Yeah, that's a good question. I've been thinking of that. I'm leaning to say that, of course, in cases of mass atrocities like egregious human rights violations, as those that the Inter-American Court have dealt with. Maybe for those cases, this model doesn't work very well. I think that these are more. I'm thinking more on violation of political rights and the kind of rights underpinning participation, accountability, general accountability. Not in those, I would say, that extreme cases, because I think it's more difficult to present this dialogic approach. And the list model, I think it's very helpful, because I started working with the democracy and distrust and all the literature that has built on that idea, because that model kind of present the court's role as a kind of more discrete way. So where the court should just be concerned of the functioning of the political system and the protection of minorities, and excluded from the political decisions. And and there are some authors that are expanding list theory, as for example, because one would say that you have to assure social and economic rights if you want to have a free and fair political process decision. But I'm trying to avoid that. But yeah, you're right. I have to do the distinction, because of course, if some is an atrocity crime, I'm sure I will have to present this as a caveat. Thank you.
Sure.
I don't know if I answered your question. Maybe.
Yeah, I'm satisfied. Yeah.
Okay.
Thank you. What about you, Samuel? Did you have any thoughts that you would like to share, or questions you would like to ask?
Yes, thank you. Hi, Mateo. It's nice to meet you. I really liked your presentation. I really think it's very interesting to consider international courts as possible democratic protectors. What I think is that what I see in your slides and in your abstract are two ideas: a normative idea of defending the idea of international courts being the guarantors of democracy, and a descriptive idea of what has the Inter-American Court and the African Court done in the past to successfully protect democracy, or to push democracies in that process of democratic backsliding to the end of authoritarianism. I think those two ideas are very ambitious by themselves, and from my perspective, cannot be solved in one only paper. I think it would be ideal if you could separate these ideas, and if you want to solve both problems, it's fine. But I think it would be best to attack them individually, because from the normative perspective, you have what you described as a democratic problem. What is the democratic legitimacy of the courts to protect democracy into the countries of the system? And also, you have another problem that I think, I don't know if you considered, but is the interventionism problem, the colonialism problem. What interest lay behind those courts? Behind the Inter-American Court, it's the OEA and probably the United States and whatever. And that's another problem from the normative perspective that should be addressed. And from the descriptive perspective, of course, you have cases that already happened, successful and unsuccessful, like you mentioned, Uruguay or Peru, but you also have the unsuccessful cases like Trinidad and Tobago, what happened with the death penalty, like Venezuela, and in some point also Peru. So I think that's my main reading of your paper. I don't know if you agree, but that would be my suggestion, to think of it as two separate problems, and maybe in the future you could put them together in one only paper. But attack them individually. And the other question that I had is if you have considered the timing. Because as you mentioned, democratic backsliding is a slow process of demining the democratic institutions that sometimes you can perceive that is happening, but sometimes you don't until it's done. And at the same time, court proceedings, at least in these courts that you are pursuing to study, courts cases take time. Cases in the Inter-American Court sometimes take 5 years, and sometimes they take 15. So what is going to be their effectiveness if cases take too long?
Thank you so much, Samuel. Nice to meet you as well. With regard to this, to the first comment, yeah, you're right. It's an ambitious project. I'm still dealing with the scope of my project because this is maybe it's gonna be a paper, but this is the project of my whole PhD research, which that means that I'm trying to set a research that will take around 3 to 4 years more. So that's what I didn't want to keep my research question so narrow and be a little bit more ambitious. Yeah, and something that I've talking with my supervisor was that I have to propose a question that will lead me to a kind of open answer, not a black and white question, because I started asking, well, courts are legitimate to intervene in democratic backsliding process. The answer is yes or not. But what happens if I find out that the answer is not? So my whole research was just to say, no, that's fine, but maybe it's less interesting. That's what I'm keeping this more broad. And the second question, the second comment, I completely agree. That's something I've been thinking of, because there are kind of and it's a literature of effectiveness of international courts addresses to some point this. It's a kind of distinction between conditions that are under the control of the courts and conditions that are out of the control of the courts, which are, for example, the appointment procedure, the procedural rules as well, that were those like factors that the courts cannot change. And timing is a kind of we are concerned, because it's part of fall of the in the case of the Inter-American Court. The court has taken so much time to rule on some cases, but at the same time, some cases are for a long time as well before going to the Inter-American Court in the Inter-American Commission, and that's something that I don't know. I think that the Inter-American Court can do nothing about it. So yeah, I'm still thinking how to include those structural dimensions of the court, but I'm not sure if I want to explore that. Maybe I will stay with the conditions that are under the control of the court, which is basically the way they deliver the decision, the remedies they adopt. Maybe precautionary measures will be a good way to think about this problem of timing. But yeah, thank you so much. It's very helpful.
Slight naive question from me on this question of timing. So I'm based in the kind of social sciences, and for us, the number of case studies that you're proposing would be quite large for a thesis. I don't know if that's the case for your field as well. I just wonder whether looking at those potential case studies through the lens of timing wouldn't help you to refine those down a little? I don't know, but maybe that's just a naive question from me. So I'll open to the floor and ask whether anybody else would like to ask any questions. Please feel free to use the chat and or raise your hand as you wish, and I will do my best to keep an eye out for people who'd like to speak. Okay, we have a question from the chat from Federico. Do you think there are ever cases in which preventing democratic backsliding would undermine the role of regional human rights courts of protecting rights? And then a second question, are these two functions of these courts necessarily aligned, or can they conflict? So would you like to have a stab at one or both of those, Matteo?
Yeah, thank you, Jorge. Well, I think that's the case of Uruguay. That's the Hellman case, where the Inter-American Court ruled on a well-functioning democracy, and to some point that undermined the role of the court as an relevant actor in the American discussion. Because I guess, of course, there are other views on this, and some support this idea of human rights as kind of principles out of the democratic debate. I'm not with that position. I'm thinking more on rights as an outcome of the democratic debate, which means that in that case the court basically took that for some people took that role of this kind of epistemic elite that basically don't care about the democratic and truly democratic processes that are taking place in the countries. And that's another thing that's related with my because democratic backsliding, as I said, is incremental and systematic. Sorry, it's incremental and systematic, which means that in a country that's suffering a kind of backsliding trend, there will be truly democratic decisions. But yeah, thank you so much, Jorge. But yeah, that's part of what I'm trying to find out. You have your.
You are muted, Diane.
I was just going to ask Jorge if he wanted to say anything in response or type anything, but yes, and I was the one without the mic. Okay. Majida's thanking you for a great presentation, very interesting subject.
Matthew, I have a question. I mean, I think if nobody has I was just wondering, you know, when the concept of democratic backsliding, I think this, I wonder how you did talk about how you are going to operationalize it, but if we compare Latin American countries or any developing weak democracy, authoritarian, hybrid regimes, you pick the label, with established democracies. So this process of democratic backsliding is a kind of a continuum. It is a very relative fluid concept. I mean to suggest that it does occur sometimes in established democracies during some periods. For example, in the UK during Blair's regime, Tony Blair's regime, in the end of that period, people started suggesting similar kind of concepts, similar kind of process. Recently in the US, we have different developments suggest that democratic backslidings do happen. I just wonder, how do you differentiate between these two different kinds of, I mean, what are those boundaries? What are the parameters that keep it separate, you know, that differentiate between these different kind of democratic backsliding? Because ultimately this idea of democratic backsliding's nature and scope was borrowed from those jurisdictions whose nature and the seriousness and the gravity is much lesser than what's happening in the global south or the weak democracy or authoritarian hybrid regimes, whatever label you want to put there.
Yeah, that's a good question. Actually, when I started thinking of democratic backsliding, I had the same impression, like this is not a problem just of global south countries. It's a problem of even the most well-functioning democracies, and that's why I'm trying to kind of challenge or propose a complementary view of the courts, different to that of one mentioned on courts as democracy builders. That's part of the explanation about the constitution. I focus on the Colombian, South African, and Indian court, but I think that this will be helpful for even well-functioning democracies. The thing is that the problem is that as I'm working on these two tribunals, the gets to the global south discussion, but I'm not thinking in global south terms. That's the point. That's not part of my main interest. This would work, for example, in the UK case, if I will, or in Europe in general, if I would choose the European Court of Human Rights. I didn't choose that court because it's more explored, and I wanted to keep my case study on these courts. But yeah, you're right. I'm not making a decision, that distinction.
Does that help now, man?
Yeah. No, I think that was very clear. I think that clarifies. Yeah, that addresses my question.
Okay, well, thank you very much, everybody. I don't see any further questions in the chat, but I'm sure everybody's going to be following your work with great interest, Matteo. I also think you might want to go and get a warm drink and just look after yourself for a little bit, because you sound pretty poorly. So please, I do have a hand up. Sorry, Gifty. Would you like to ask a question? Sorry, I've just seen that popped up.
No, just to encourage Matteo that the journey is long, but then I think he started well, so he should keep it up. And that's
that's definitely what we all need to hear sometimes, especially when you're feeling a bit under the weather.
Thank you so much.
You're welcome.
Take some good care of yourself, Matteo. I think there's a session next week as well, Nauman, is that right?
Yes, I have put it there in the chat box.
Oh, fabulous. Okay, so next week our guest is Mohammed Ghulam Sawar from the School of Oriental and African Studies, University of London, who's going to be presenting on their project entitled Making Just Transitions Just for Developing Countries, Synergies Between Responsible Investment and Climate Justice, which, given the news today about climate change and a potential 3% rise, 3-degree rise, perhaps we should all be paying attention to that topic. So I look forward to seeing you next week, and be well, everybody.
Thank you.
Thank you so much.